Welcome back to another episode of Wiley Ryan's Government Contracts Podcast. I'm Craig Smith, a partner in the group, here with my partner and co-host, Brian Walsh. Brian, how you doing today?
I'm doing great. It's nice and cool and rainy out. Feels like fall, feels like football season.
Well, it's not only that, it's a new year.
Oh, it is a new fiscal year, yes. I saw the fireworks go off last night over the GSA building.
It was probably a couple of award decisions being sent to the companies at close to midnight. So with the start of the new year and the traditional protest season, we thought, hey, let's take a minute and talk about kind of what we're seeing about choice of forum and how more so than I think we have at any time in our practice history here, talking about the Court of Federal Claims versus GAO and some of the choices that protesters are making when they choose to litigate in one forum versus the other. And to help us talk through that today is our guest, Ryan Frazee. Ryan's a longtime colleague here in our government contracts group. Ryan, welcome aboard.
Hey, Craig. Thanks for having me.
And so, Ryan, in a nutshell, for those who maybe don't have the opportunity to think too much about one forum versus the other, do you want to just give a quick overview of kind of your experience with what one forum offers versus the other?
Yeah, that makes a lot of sense. So I've been doing this for about 10 years. And when I first started practicing, GAO is pretty much the primary forum for bid protests. It's where most of them would be filed. I think we've been seeing more of a trend to more protests being filed in the Court of Federal Claims, but those are the two primary fora where if you are challenging some aspect of a procurement, that's kind of where you bring your challenge. So what's interesting about the two is each one kind of has different factors that may be more or less valuable to you depending on what your protest ground is. One of the big differences is the timing for when to file a protest and when they get resolved. Typically at GAO, you have about 10 days to file your protest, except in limited situations where there's a requested and required debriefing. Then you have 10 days from the basis that you learn of your protest grounds. So for a debriefing, you can typically file a little bit later. At the Court of Federal Claims, that jurisdiction is under the Tucker Act, so you have a much longer period of time that you can file. It's generally advisable to do so on the earlier end. That'll help you with a couple of other things that we'll talk about in terms of prejudicial impact and getting an injunction at the court. But typically when you're talking about a protest or thinking about a protest and you get an award decision that's not good for you, if you want to file a protest, you got to start thinking about it very quickly if you want to do that at GAO. So why would anybody want to file at GAO that quickly and kind of hair on fire sometimes collecting your protest grounds and drafting the protest and getting counsel involved?
I have an idea, but I want to hear yours.
Well, so the effect of the protest is different depending on where you file. If you file at GAO under the Competition and Contracting Act, you have an automatic stay of performance. And that's really important because if you end up prevailing on your protest, you don't want to have the presumptive awardee to have already been starting performance. This way, the agency can't proceed with performance of the contract. They have to stop everything until the merits of your protest are resolved. You don't automatically get that. At the court, you have to ask the court to enjoin performance, which typically requires you showing a likelihood of success on the merits. It's not automatic. You basically have to fight it out on the merits, do all that briefing, and get the win before you can have the court order the agency to not proceed with performance.
And at GAO, you get that stay if you file within 10 days of award or 5 days of a timely requested required debriefing, right? Am I remembering correctly?
Yeah, that's correct. And that's another good point about why it's a good idea to bring in counsel early on is, when is a debriefing required? If the agency just says, hey, I'm going to, give you a debriefing at some later date, that doesn't automatically mean that you get your COFC stay if you file within 5 days. So there's, some analysis there to determine whether or not a requested debriefing is in fact required.
And if you go to the court, it's possible the DOJ and the agency could agree to a stay, right? That has the effect of almost an automatic stay in terms of it's not a huge briefing and argument effort, but it's not mandatory and automatic in the way that the COFC stay is in a GAO protest.
Yeah, that's correct. So when you go have a protest at the court, the Department of Justice becomes the counsel that's involved with litigating it. And they can coordinate with agency counsel and agree to a voluntary stay of performance. And we've been seeing that, I think, an increasing trend in terms of DOJ's willingness to do that. They kind of are willing to, defend the award decision if there is a challenge to it and preserve the right of the agency to end up, if the protester prevails, to make an award to a new awardee. So we're seeing like an increase in voluntary stays. I have heard rumors that DOJ is reconsidering their willingness to do it in as many instances as they have, but that is an important factor if you do file at the Court of Federal Claims, trying to engage with agency counsel as early as possible and see if they're willing to do a voluntary stay.
Well, why, if you don't get if you don't get an automatic stay like you do at GAO, which is probably very valuable, especially I think to incumbents, why would you go to the court? I mean, that just seems like not as good a venue without the automatic stay.
Yeah, and I think that's why traditionally there is a push to go to GAO to get that automatic stay, but there are some benefits for the protester of filing at the Court of Federal Claims. At GAO, the record that the agency ends up producing and that you fight it out on is limited to the documents that are relevant to your actual protest grounds. So you don't automatically get the entire administrative record. If you just challenge your evaluation of your proposal, you're only pretty much going to get your proposal and the evaluation of it. You're not going to be able to see the awardee's proposal, and that's going to limit the number of supplemental protest grounds that might be available to you. At the Court of Federal Claims, the whole administrative record gets produced, and the agency has to defend the entire thing. So you get to see it's a larger record. It typically means that protests at the Court of Federal Claims are more expensive because there's more documents to review, but you also don't have to spend a lot of time, fighting it out on the front end about what documents get produced and which ones don't, which is a common point of litigation at GAO prior to the production of the administrative record. And it typically kind of increased costs, and it's usually briefing that has to be done on a very tight turnaround. You don't have to worry about that at the court. You get the full record, and the agency is going to defend it, and everybody's going to be able to see what the agency did and how they documented it. And the court is going to have a full factual record on which to render a decision.
Of course, you've got to make sure, even though you're anticipating a broader record at the Court of Federal Claims, you've got to make sure the record's actually complete. I think we saw that with the recent Federal Circuit decision, the Oak Grove decision, where there were sanctions at the lower court, at the trial court, because the agency hadn't finished the record and there were some relevant documents that weren't included.
Yeah, that's always a risk. That's, there are going to be documents that you're going to expect to see in the record. And if you don't see them, then you should raise that as soon as possible through a motion to supplement the administrative record to make sure that all the documents are in there. I think that recent Federal Circuit decision is an outlier, at least in my experience. What I've been seeing with protests at the court is there's usually a lot of coordination between the protester, any intervener, who's usually the awardee, and the Department of Justice and the agency kind of on the front end to agree, hey, here are the documents that we think should be in the administrative record. Let's take a look at them and make sure that they're all in there. So that way we can kind of present to the court, an administrative record that everybody agrees is full and complete, and the court isn't involved in discovery disputes, which they never really like to get involved in.
Stay focused on the real issues.
Yeah.
One other kind of thought that I have when I think about the two is you mentioned the briefing, and usually you've got to deal with page limits at the court that you don't necessarily have to at GAO. And so in some ways, either you've got a distilled story or you don't. And so maybe that's a factor to consider, as well as how much do I have to actually argue about potentially?
Yeah, that's a good point. It depends on how many protest grounds you're going to raise. It's not the norm, but it's not unheard of at GAO, where you might see a protest that's 80, 90 pages long, very lengthy, kind of raising every possible issue. At the court, you have your page limits, and you have to move for leave from the court to file larger briefings. So, if you have a couple of clean issues, especially if they're substantive ones that you think are strong at the court under their case law, that could be a preferable forum to go to. On the alternative, if you're raising 15 different protest grounds, GAO is probably the place to go to make sure that you get everything, that all of your arguments are in front of the GAO attorney who's going to be making the decision.
Once you've decided, you really need to make them all too.
Yeah.
And we've talked a lot about maybe process, but there's also some decisions that come out on the merits, I'd say maybe not identically, and those could play a role, right?
Yeah, that's exactly right. So it depends on what your protest ground. You may have a better chance at GAO versus the Court of Federal Claims. And I think everybody in the practice area has noticed that there have been recently a few more deviations from Court of Federal Claims case law versus the standard at GAO. One of them, which is an older deviation, but is the timing for when a proposal is due for submission. It's kind of known as the late is late rule in GAO. In pretty much every respect, takes a pretty hard line in terms of timeliness, which is kind of consistent with their mission to quickly resolve protests so that procurement decisions aren't tied up in this extensive litigation. So their rule about whenever a proposal is submitted to the agency outside of the proposal submission deadline, If it comes to the agency 1 minute after the proposal deadline is due, late is late, and the proposal is rejected and cannot be considered for award. There's a couple of cases that I think talk about an exception to the late is late rule, and that's the government control exception. You submitted your proposal in a timely fashion. The government has it. It just hasn't filtered its way up to the procurement individuals. GAO, a couple decisions I'll talk about from the early 2000s, PM Tech and CBOX dealt with electronic submissions of proposals, and I think tells a story about how strict GAO is in enforcing their timelines. In PM Tech, I think proposals were due at noon. The protester started to upload electronically their proposal at about 11:48. They got the cover page loaded up on the agency server before noon, but everything else didn't come until afterwards. Their GAO said, late is late. You got your cover page. That's not the entire proposal. The rest of it didn't get to the agency server until after the deadline. And so the proposal couldn't be considered for award. CBOX is an even more stricter application of the government control exception. There, the proposal hit the agency servers within the deadline, but didn't make its way through the electronic security systems into the contracting officer's inbox until after the deadline. There, the protester argued that the government control exception should apply because they timely submitted the proposal. It was within the agency's possession electronically. It was on their servers. There wasn't anything that the protester did that was wrong that caused the proposal to be received late. And GAO declined to apply the government control exception there. They viewed that as not really applying to electronic submissions of proposals, but instead, the physical delivery, like you delivered it to the agency's physical receiving box. It just hasn't made its way through their mail system. GAO found that exception didn't apply to electronic submissions. Whereas about a decade later in Watterson Construction, the court had a similar factual pattern, and there they found that there's no reason not to apply the government control exception to an electronic proposal submission. So if you're dealing with a proposal that's been rejected because you uploaded it in time, but it was nonetheless rejected by the agency because it wasn't received by whatever reviewing official until after the deadline, the court is the better avenue for you than GAO.
Of course, it also makes me think, this is a reminder, start sending those proposals in earlier, leave buffer time, but that's good advice in general, but sometimes companies find themselves in these situations.
Yeah, I mean, this has gone on, for 20 years. GAO is still living in like 1986 or something, and it's with fax machines and delivery, and they do like to apply their latest late rule very harshly because most proposals now go in electronically, and we had the amount of latest late cases that come out every year is astonishing to me. We lost one earlier this year where the proposal got 9/10 of the proposal made it through. One volume got taken out by the agency's spam antivirus filter and got cordoned off, and the agency had it, but they didn't know they had it because it had been blocked off by the firewall. In that case, our client got evaluated as not having submitted that version. And GAO said, well, that's your problem still because you could have submitted it earlier, I guess, even though it would have still earlier gone to the spam filter or whatever. So it's sort of shocking to me that we're still dealing with this, but the court is much more friendly and more pragmatic in my mind when it comes to late stuff.
Well, the proposal goes in. It actually gets in, it's uploaded, hooray. Then the agency's evaluating it, and your project manager, a key person, wins the lottery and fulfills a lifelong dream to move to Estonia. And, I think that's another area where we're seeing some divergence between GAO and the court, key personnel.
Yeah, I think that's right. I haven't seen that exact fact pattern that you referenced, but one of the more recent shifts and divergence between the two does concern key personnel. So at GAO, if you submit a proposal and you have actual knowledge that one of your proposed key personnel, your program manager, whomever, is no longer available to perform, you have a requirement to inform the agency that your key personnel is not available. And the reason why that's a harsh rule and a difficult rule for contractors is once proposals go in, you can't make any changes to your proposal unless the agency opens discussions with everybody else that submitted proposals. So if your key personnel are no longer available, the agency has two options under GAO case law. One, they can reject your proposal as non-compliant and not meeting the solicitation requirements because you no longer have your program manager, or they have to reopen discussions with everybody, which is a headache for the agency because instead of just dealing with one discrete issue, they've got a flag for every other offeror the deficiencies, the big problems with their proposals, and give them a chance to fix them. A couple of years ago, a case came out at the Court of Federal Claims and it was Golden IT versus United States in 2022, where the court rejected GAO's standard. There, the court viewed a proposal as a snapshot in time, basically. These are the people that we're proposing to fulfill this requirement. And as long as the offeror at the time of submitting the proposal had every intention of having these key personnel perform, they had no further obligation to update the agency, even if they had actual knowledge after proposal submission, but before award, that there was a change. So key personnel is one of the more frequently litigated protest grounds. And it typically, especially with the GAO rule, has led to a lot of LinkedIn searches and, seeing if anybody's changed jobs and whether or not the offeror has actual knowledge that the key personnel are no longer available. So that's going to be an argument that will carry the day at GAO and is probably worth trying to meet the shorter time frame to file. At the court, you're going to have a higher burden to win on that. You're going to have to show actual knowledge at the time of proposal submission, which if you're able to show that, the awardee's got bigger problems than just losing the protest. They've submitted a proposal that they knew was inaccurate.
Yeah, they have FCA problems then. And I think Judge Solemson and GAO are definitely diverging. And I think Judge Solomson's probably got the more pragmatic, more fair interpretation, because everything else in the proposal is a snapshot in time. With that being said, I think there's one other interesting area involving what you just mentioned, why the agency wants to avoid key personnel changes and having to open up discussions, but discussions in general. I think that's another area where we see a divergence sometimes.
Yeah, so there's a DFARS provision that requires, I'll say the language of the DFARS provision says that for defense procurements, estimated value of over $100 million, the contracting officer should hold discussions with all the offerors. GAO has viewed that language as sort of a default process that can be overcome if there's some sort of documented basis by the agency to deviate from it. And they've applied what's known as the SAIC test, which to determine whether discussions should be required in an instance. And it's a 3-part test, whether there were deficiencies in the protester's proposal, whether the awardee's proposal was evaluated as being technically superior to the other ones, and whether the awardee's price was reasonable. So 3-part test, not really found in the text of the DFARS clause itself, but...
And that's 215.306?
That's 215.306. Another recent Court of Federal Claims deviation from the GAO case law concerns that very issue, and they found that there is a strong presumption that if there is a defense procurement with an estimated value of over $100 million, a strong presumption that discussion should occur, and explicitly rejected that 3-part test from GAO as being kind of untethered from the text of the DFARS provision, and effectively turned the meaning of the word discussion should occur to discussions may occur. So again, if you're concerned about whether or not you had an opportunity to submit a final proposal revision because of if you got a defense procurement for over $100 million, the Court of Federal Claims is going to be the better avenue for you there. And GAO, you're going to have to meet this separate 3-part test.
And then one thing, just to go back to that Oak Grove decision we mentioned earlier from the Federal Circuit, but another lesson there is, because they dealt with this provision specifically, is if there's any confusion in one of these procurements that could be subject to the 215.306 rule, so over $100 million at DoD, if there's any slight lack of clarity about whether the agency intends to hold discussion, that's a pre-award protest issue. So don't wait until after award to figure out we should have had discussions. You should there, I guess, quite literally. That's a timing issue to pay attention to. We've been trucking along and we didn't have a chance to read a message from our sponsor. Today's episode is brought to you by 24-hour notices. They're the Omar Coming of the bid protest world. 24-hour notices. And Ryan, we've had such a great time with you. Thanks so much for joining us. Really appreciate kind of thinking about, hey, I've got a fork in the road ahead of me with a protest. Where do I want to go? These are some real practical considerations, both process and the law. Thanks again for joining us today.
Thank you both for having me. It's been a real pleasure.